All right, back with another one here today with Zack Shapiro, starting to become a staple here on the PPI podcast. So thanks for joining, Zack.
Of course, glad to be here. Although, as usual, the subject matter is kind of unfortunate.
Yeah, I know you and I we're really on the downer podcast here, but hopefully 2025 we can bring some more positive ones here. Um, okay, so the topic today is a sort of recent happened a couple weeks ago, IRS rule change. And the great thing about this rule change was that it was done either on Christmas Day or maybe the day after, sort of snuck in right before the new year. Uh, and it's a bit of a doozy. So I want to just go through that. So just to start us out here, what exactly was that rule, and what was involved in sort of getting to that rule? Because it's not just like came out of nowhere.
Yeah, absolutely. So there's a bit of a history here, both of the government trying to release anti-self custody rules right around New Year's. You can recall from the end of the first Trump administration, there was a rule that would have required self custody wallets to dox their users, which probably would have been impossible to comply with. And so this is the Biden administration's, I think, version of this. The sort of history of the part of the rule we're going to talk about goes back to the infrastructure bill that you might remember from 2021 is one of the first times the industry really sort of flexed its muscles. And there was a part of the infrastructure bill, there was an attempt to expand the definition of what a broker is to include non-custodial, essentially DEX tools, right? Like front ends and smart contracts, stuff like that. There was a big political outcry at the time. 6 senators wrote a letter and ended up killing that expanded definition. And then it came back in 2023, where there were new IRS rules, reporting requirements for brokers. The first part finalizing rules for custodial traditional brokers. And then this last piece is a final rule after a notice and comment period where the crypto industry wrote in and explained its issues with treating non-custodial services as brokers. There is a revised version that became the final rule that we just saw, I think, the day after Christmas. And so this is, a final rule. There's no more opportunity for notice and comment from the industry. The rule doesn't go into effect until the beginning of 2027. So there's some time here before it goes into effect. And as I'm sure we'll talk about a bit more, I'm skeptical that this will ever fully go into effect, but it really is sort of an alarming sign and sort of a pattern of anti-self-custody rules that sort of fail to either accidentally or intentionally fail to draw a distinction between regulations that apply to a third-party intermediary in financial transactions that's a financial business of some sort or another, or just software that facilitates peer-to-peer transactions using a blockchain. This rule in particular, the first version of this that we saw in 2023 creates a category of facilitative services for DeFi, which are services that facilitate movement of funds or facilitate trades, and those are treated as brokers. As a result of a bunch of comment letters from the crypto industry, they slightly modified the language in the final rule that we just got to effectuative services, right? So these are services that effectuate transactions on the blockchain or DeFi transactions. And if you dig into the actual IRS language, they address some of the arguments that the industry made that you can't effectuate transactions. The statute that this is all based on defines a broker as someone who effectuates transactions on behalf of the public. Almost everyone who wrote in said that would require, in the case of crypto, for you to be holding people's keys, right? Like a centralized exchange or some sort of custodial service. The IRS rejected that. And they said, in much the same way that traditional securities brokers can come together to effectuate a trade, that, for example, a DeFi front end, a DeFi user, and then a non-custodial wallet that the DeFi user is using to sign can come together to effectuate a transaction. And therefore, these regulations can apply to software that does not hold your keys, that doesn't actually effectuate the transaction, I guess, in the ordinary sense of the word. I guess I'll pause there.
Yeah, so I think you're spot on here. Particularly just thinking about sort of the evolution of this thing and also the corollaries to other sort of self-custodial issues that we've been facing, and we'll get to that in a bit. But um, one thing that I think is really helpful for people to understand, and something that I think generally gets missed, is why exactly a non-custodial broker or a non-custodial service at large um, can't report this kind of information. It's not technically feasible for them to do that. So can you sort of explain what the difference is here and why that isn't feasible?
Yeah, so I think it depends a little bit on what type of non-custodial service we are talking about. So a immutable non-custodial service like a smart contract for a decentralized exchange. Let me just break that down. A smart contract is a computer program that lives on a blockchain, which is how most cryptocurrency works. Immutable means that it's not under the control of whoever developed it, right? Whoever developed it burned their keys, burned their ability to change it, and it sort of lives on its own. If you write code for example, a pre-existing immutable smart contract that people use to swap from one crypto asset to another, you can't stop it. It works in a permissionless way. It's just sort of like this is not a perfect analogy because you can control vending machines, but in some ways it's like a digital vending machine that lives on the internet, and people can just put in their digital dollar, get out their digital good or service, and that's all there is. And so you can't stop people from using it. And because blockchains are generally pseudonymous, meaning you can see the transactions that are happening publicly, but you don't know, for example, one crypto address belongs to what human. You're just not in a position to know who's doing these transactions. Now, there is another way in which you could think about this for non-custodial services that are not yet built, whether that is front-end software, meaning like an ordinary website someone would use to help them interact with some of these smart contracts. So for a decentralized exchange or DEX transaction, the way most people would interact with a DEX is you first have a crypto wallet. MetaMask is one of the most popular ones, and that allows you to sign transactions with your private keys and interact with blockchains. Then you have a front end website, which is basically a user experience layer that can help you connect your wallet to the smart contract sort of vending machine where people are listing other assets for sale. And then you type into that front end website, here's the transaction I'd like to do with my wallet. The front end website helps queue up the code for that transaction that the smart contract can read. And then you hit the button in your wallet, in your MetaMask software, and that is you signing the transaction that gets sent to usually through a node that's run by your wallet. Infura is one of the big node runners that works with MetaMask. And that transaction gets sent to the smart contract, and then you receive the other asset that you're swapping for. For each of these players, if you're looking at the non-custodial wallet or you're looking at the front end, it is possible, and this is sort of the biggest, most troubling part of this new IRS regulation, it is possible that the software provider could have, as a condition of your using the software, required you to KYC. Right, MetaMask could have its terms, part of its terms of service, that you have to KYC who you are to use MetaMask. DeFi front ends theoretically could reject you connecting your wallet unless you upload your driver's license or something like that. So in some sense, and under the IRS language, these software providers are technically in a position to be able to ask for people's information. What they aren't doing, though, is effectuating people's trades, at least as anyone understands that. And so we'll get into maybe later some of the legal challenges, but one of the sort of straightforward constitutional problems with this IRS regulation is it's what's called a prior restraint under the law, which is a problem under the First Amendment, where it is a ban in some sense on writing software in the way you want. If I'm to just write a DeFi front end, just a piece of software that people will use to interact with something like Uniswap, then I have to add surveillance to that. I have to add KYC, or else if I just write that software and I publish it on the internet and then people use it, I will be treated as a broker for having written and published that software. And so it's a civil liberties problem, I think, under the First Amendment. It's arguably an unreasonable search and seizure under the Fourth Amendment. because you're compelling surveillance. And I think the other big legal problem here is it's not what is meant in the statute by effectuate.
Right. Yeah, that's great. I think that was kind of the thing that definitely stood out to me too. Um, as far as just kind of reading through some of the challenges to this particular rule was, yes, technically it's possible that all these, sort of DeFi platforms or whatever could require KYC, and therefore be able to report such information to the IRS as far as sort of what each transaction contains and those kinds of things. But they're not actually facilitating the transactions themselves. They're not effectuating the transactions. And so, what's the sort of requirement in the first place? So, I think it's very well said on that. I want to go to a tweet that you had put out a couple weeks ago, and I believe this was in response to the Coin Center uh, article. You said, "My quick take: these regs are terrible, unconstitutional, and thankfully unlikely to ultimately go into effect in 2027. This is the swan song of Senator Warren's anti-crypto army." Do you want to just elaborate on
Yeah,
that
for
for
sure.
us?
So let me take each piece of that. So by terrible, it first of all, it's incredibly hard to parse. It's there are many pages trying to explain what effectuate means in this rule. It is going to be difficult for even sort of well-seasoned tax and crypto lawyers to figure out who this covers and who it does not. Even in the sort of updated version of this rule that had a notice and comment period. It's also terrible insofar as it sort of bastardizes what the word effectuate means, which both is a problem in this regulation. I think it is a legal problem, a problem of statutory interpretation. It goes beyond the IRS's authority, and it sets really bad precedent that is not just going to apply to tax cases. I think this is a broader example of the law failing to distinguish between peer-to-peer transactions on the one hand, and transactions that are effectuated by a trusted third party intermediary on the other. And this is very similar to the type of issue we see in treasury cases, right, and criminal cases against Tornado Cash and Samurai Wallet, where in that other context, the law is treating software as if it were a money transmitter, as if it were a sort of third party intermediary. I think the more of this precedent that we have pile up, the harder it's going to be for the whole ecosystem to draw this distinction that's really critical if we're going to have any kind of sort of peer-to-peer blockchain-based transactions or decentralized finance. So it's a bad rule. It will set bad precedent. It doesn't make a ton of sense. Unconstitutional, I touched on a bit before, but it seems to me like it's a First Amendment problem. It's an implicit ban on publishing code that does not include surveillance. I think for that same reason, it's probably also a Fourth Amendment problem. I think it's unreasonable search and seizure. If you look at the Carpenter precedent from the Supreme Court, I think there's some support for this. And so there's already been a pretty robust lawsuit brought by some of our colleagues at the Texas Blockchain Council, at the Blockchain Association, and at the DeFi Education Fund, mostly to sort of mark and preserve a legal challenge. I think also Congress, under the Congressional Review Act, has 60 days to review and basically revoke this rule under its authority. And I think there's a pretty good chance that the incoming Congress, which is, I think pretty much undoubtedly the most ever pro crypto Congress, and certainly the first time we've had an election that crypto is a major issue, I think they're likely to take the industry up on that and use the CRA to roll this back. So one way or another between now and the beginning of 2027, my guess is that this won't end up becoming binding law. But if it does, that would be a real problem, especially for the DeFi industry. And then in terms of being the sort of last gasp of Elizabeth Warren's crypto army, it's no secret that in the past 4 years, Elizabeth Warren, who is a sort of staunchly anti-crypto advocate, has had a lot of power in the Biden administration, largely through her influence on staffing. Gary Gensler, the banking committee, Sherrod Brown, and that's been exercised in a whole bunch of different ways to try and make life difficult for the digital asset industry, whether that's Operation Choke Point 2.0, whether that's the proposed DAMLA bill that would treat basically all industry players as money transmitters, whether it's the sort of SEC's war on tokens and decentralized exchanges as brokers, which is also sort of a similar question to what we're talking about here, but under the securities guise rather than under the tax guise. This finalized rule is, I think, very much in keeping with that spirit. And I strongly suspect that the IRS under the incoming Trump administration is not going to take this tack. If Congress pushes back on this, if the lawsuit moves forward, I think they have every incentive to take a look at this and not kill DeFi with an absurd rule like this. So at least the way I view this now, I mean, I don't want to minimize it. It really is an awful rule. It's illegal. It's an attack on crypto. But I think this is really more of an expressive act by the outgoing administration, and specifically those in the outgoing administration who are against our industry, than it is a clear direction for things to come from a regulatory perspective.
Okay. So the last kind of thing I want to jump into here with you is thinking about the corollary to the Samurai Wallet and Tornado Cash cases. That's obviously been something we've discussed here before. Can you sort of just walk us through sort of the similar lines of reasoning here that seems to be motivating a very similar sort of mistakes, I think we could label them as far as understanding of the technology? How does that sort of break down between the two?
Yeah, I think it's actually a pretty simple principle. The innovation of blockchain technology that we got from Satoshi Nakamoto in the Bitcoin white paper is that it is possible to effectuate transactions over the internet on a truly peer-to-peer basis, right? Using a consensus mechanism like proof of work. And that works, someone broadcasts a transaction to a decentralized network. There is a set of rules that incentivizes the network to codify that transaction onto the blockchain, which is the record of transactions. And that is what moves the funds in question. It is not communication from one party to another party and then an update of a ledger that's maintained by yet another party. And for that reason, when we're talking about blockchain, whether a sort of ordinary peer-to-peer Bitcoin transaction or a complicated DeFi swap using smart contracts and a liquidity pool, the person who is doing the transaction, the person who is transmitting money, the person who is effectuating a swap is the person who is signing with their private keys, right? It is a transaction from one person to another with only software in between, whether that software is the blockchain or the blockchain plus some other program like a smart contract. If there are no third party that is holding a user's keys on their behalf, we would call that a peer-to-peer transaction, right? Just software in the middle, no trusted third party. What both of these instances have in common is trying to impute a third party where there isn't one. And the problem with doing that, when you try and impute a third party where there isn't one, the natural person to go after, in the case of blockchain-based tools, is a developer, is someone who just wrote the code that people are using to transact one to the other, whether that is a asset swap or whether that is a privacy preserving transaction like in Tornado Cash and Samurai Wallet. And so whether it is throwing someone in prison for not KYCing people, in the case of Tornado Cash or Samurai Wallet because they're running allegedly an unlicensed money transmission business, or whether that is fining someone for not reporting to the IRS when you didn't KYC them, when you're running the front end for a DeFi set of smart contracts for a decentralized exchange. This is just the mistake of insisting that there must be an intermediary when there isn't. And look, this is a new paradigm. This is something that both regulators and legislators and federal judges are going to need to wrap their minds around. But we're in this sort of dangerous period where I think this concept is really new to people. It is somewhat difficult and complicated to fully take on board. And, we run the risk of creating a lot of bad law in the meantime if we get this issue wrong. Bad law in the Treasury context, like we're seeing in Tornado Cash and Samurai, bad law in the securities context if we're treating DeFi smart contracts as securities brokers and making them liable for that, or in this IRS context where we're treating people as reporting brokers for IRS purposes.
Yeah. Yeah, that's great. All right. I think we covered all the bases here. I guess final question for you is you obviously think that this, doesn't really have much legs. But is there anything sort of actionable here? Is there anything we should be on the lookout for, or anything that folks can do to get involved on this?
Yeah, I think the best thing folks can do who are listening to this is call up your elected representatives and ask them to use the CRA to roll back this rule. I think that is the most straightforward path to getting this done. It's the cleanest, and that can happen pretty quickly. But it would be helpful for Congress to hear a groundswell of support for rolling back this rule, and that needs to happen sooner rather than later. This is a 60-day window. Other than that, if that doesn't happen, there will probably be ways to support the blockchain association and DeFi fund case. But I prefer to get this done through the CRA, and then just educating. If you're ever in a position to talk to lawmakers, if you have people, friends, family who work in government, really harping on this issue of what is unique about blockchain technology. To the extent that this is something that is valuable and new, it's that it is a peer-to-peer network, right? Bitcoin really does work, in a trustless peer-to-peer fashion, and it should be regulated differently for that reason. And when you try and regulate it the way you'd regulate old things, that's not going to work, and it's going to break a lot of the sort of non-custodial tools we need. Similar to how if you tried to use the same rules that you applied the 4 original broadcast networks to YouTube, we couldn't really have YouTube, or YouTube would be pretty useless. And so this is an important issue. This is, I think, a thing really to keep an eye on, the broader principle, and especially to folks who are listening to this who are focused really much more on Bitcoin than the rest of the crypto industry. This does matter to Bitcoin as well. It's not just other blockchain networks. Just to give a couple of examples, there are things like what exist on crypto that are coming to Bitcoin soon, whether that is Bitcoin-based rollups, whether that's taproot swaps. If you want to be able to have other assets on the Bitcoin blockchain, this is going to apply. And then I would say even more importantly than that, I want to underscore this principle that this is all the same idea of regulating peer-to-peer non-intermediated transactions as if they were done by a financial service business of some sort or another, whether it's a broker or a money transmitter. And the more precedent, whether in case law or statutory law or regulation, that we have pile up that makes this mistake, the more of that we're going to get. And the harder it's going to be to fight back against those types of rules when they show up in places we care about, like the Samurai Wallet case.
Amazing. All right. Thanks so much, Zach. Hopefully next time we talk, it's something a little bit more positive,
Yeah,
but
hope so.
always a pleasure.
My pleasure. Talk to
See
you
you
later.
later.